And welcome. So this aspect of the series is called IP for Creatives. And my name, a little about me. My name is, sorry, can you see the participant list on the screen? Is it blocking the screen? Okay. So a little bit about me. My name is Faith Chema Onuchukwu. I go with the brand name The Virtual Lawyer, and I like talking about law, and I'm very interested in intellectual property law, and this is one of the reasons why I'm taking the initiative to talk to creatives about it because I believe that most creatives do not know what it means to protect or to secure their intellectual property rights. And just a way to reach out, I decided to make this webinar. So you can follow me on my social media handles and my social media pages. You could also scan the QR code you see on your screen so you can get more access to the resources that I provide. Okay, so basically, intellectual property. Basically, for me, I try giving it an acronym to help people who don't know what intellectual property is to know it better. So I just call it the WOM, meaning work of my mind. Intellectual property is anything you create as a result of your mind, okay? Anything you think, anything you produce as a result of your thought, okay? So your music, your lyrics, your trade name, your business name, all those are things you thought of first and then you created it into your work. So it's just like your basic property, your car, your laptop. But this time around, intellectual property could be tangible, like physical. Sometimes it's not physical, but basically you just have to know that as a creative, intellectual property is also a property you have. You can even mortgage your intellectual property. So you see how brandable and how valuable your intellectual property is. Now, there are different type of intellectual properties. I mean, the ones on the left-hand side, they are more popular than the ones on the right-hand side. So you know the copyright, there's trademark, there's patent, there's design, trade secret. I'm just going to give like a general overview on what this is before we cut into the main gist of the series. So copyright. Copyright basically protects the way you craft or the way you put a work at use. So it covers work that are literary, broadcast, musical work, artistic work, choreography, sound recording, drama, and also audiovisual. So just to give an ex to explain, literary works cover your novels. If you're an author here, if you write your articles, anything basically you put in form of writing, copyright actually covers those kind of work. Broadcasting has to do with people who are, okay, for example, CNN, for example, yeah, the way they produce or present their news is actually protected by copyright. Musical work, many of us here are musical artists. Your lyrics, your songs basically are protected under copyright. Artistic work has to do with those of us who are artists, basically your artwork, your architectural designs, your graphics, basically they are protected under artistic work. Then if you know how to dance very well, your category would definitely fall under choreography. Then sound recording has to do with you putting or recording basically your phone the way same way you have your recording your sound recording in your phone, whatever you say or whatever you actually record on your phone is protected under copyright. Then dramatic works, we have your script, people who are into the screen, you have your script writing, your films, your movies, they are actually protected under copyright. Audiovisual work actually entails your anything that has both a mixture of audio and visual element. For example, your TikTok videos, your Instagram reels, your Instagram stories, those are audiovisual works and they are protected. Right, or some requirement before your work can be protected by copyright. The first is that it has to be an original work. It means that you cannot just take something that is general, something that is known, and then you decide that, oh, I'm going to protect this. Please don't use it, don't infringe on this work because I made it. So for example, let's take the general idea that cats eat fish, for example. I know it's a very funny scenario, but I think it would drive home the point. So we all know that okay, cats they eat fish. So that kind of concept cannot be protected by copyright. So let's say, for example, I'm an artist and I decided to draw a cat eating a fish. The copyright will not protect the fact that I drew a cat eating a fish. What copyright will basically protect is how I drew the cat eating the fish. For example, maybe the cat is yellow and the fish is green, and I drew it probably close to the fish pond or something like that. What copyright basically will protect is how I expressed or how original that work is to me, the color, the choices I made, the colors I add, everything basically that has to do with my decision will be protected by copyright, but definitely not the idea that the cat is eating the fish. Okay, so I don't know if that drives home the concept or if you understand that, but basically that's what copyright entails. So that's the first threshold for copyright. The second one is that it has to be fixed. During one of my video, I stated that it should have been something in your head. You can't say that somebody stole your ideas. Ideas are not protected under copyright law. So what you have to do is to put whatever is in your head, whatever idea, whatever business pitch you have, put it in writing, document it, have some sort of documentation. That is only when you can actually enforce your copyright. But to say that, okay, I told this person my idea and he stole it, it can't really fly because you won't be able to enforce it. For copyright to exist, you have to actually fix it, like put it in a documented form, something somebody can see, something somebody can feel. It can be a sound recording, it can be a writing, just anything, but not just anything in your head. So that's all for copyright, basically a brush through of it. Then let's talk trademark. So trademark is actually very popular. It's basically for us who have business. If you have a business, basically your trade name, J&J Sons. The virtual lawyer, yes, let me use myself. The virtual lawyer is a business name. So it's a trademark. It's something that you use to identify your product or your services. So that's basically what trademark is. It covers logos, slogans, the Nike, just do it. It's protected by trademark. We have trade dress, trade secret, even your service mark. Some people even use smell as a trademark. So I'm just going to brush through on this because I don't want to waste so much time on it. So for patent basically covers inventions. Okay, if you automobiles, for examples, machine, you have the vacuum cleaner, those kind of unique machines or unique innovations are protected under patents. And then design basically has to do with your packaging, how you package the product. Okay, for example, you sell bottled water and you want a particular brand. The way you package your bottled water basically will go, or you will register that basically under design. Then trade secrets. Most people actually complete patent for trade secret and they don't know when to register patent. They don't know what can fall under trade secret. So the difference between patent and trade secret is that patent basically has to do with the inventions. Trade secrets can also protect invention. However, the tweak for trade secret is that it is less expensive than patent. To file patent is very expensive. So, or rather, the intellectual property rights for trade secret basically helps you to keep your work or the way you made the work or the way you created or invented the work a secret. And this right can only last as long as it remains a secret. So a particular or a typical example is the Coca-Cola recipe. Now, a lot of people don't know how the Coca-Cola drinks are being made. And that is because it is a special trade secret. Now, as and immediately that secret or how to make the Coca-Cola recipe is found, it will no longer be a trade secret. Anybody can use it. Okay, now that's on the one side. For patent allows the author or the inventor to disclose the invention. However, after disclosing how you made the invention, the law actually gives you a right to monopolize that work for at least 20 years. So it's just like a give and take kind of thing. So the government tells you, okay, tell us how you made this invention and we'll give you monopoly. On the other hand, you see trade secret. Trade secret, you can keep how you made it a secret as long as no other person can find it. I just want to know, is any person here a businessman, a businesswoman? Okay, hi Teresa, can you unmute?
Hi, good evening.
Good evening.
Can you hear me?
Yes, I can.
Okay, so I have a question actually. It's going to take you back a bit. I know you're trying to move forward, but my question borders on trade secrets. So
Okay.
I just want to understand, your trade secrets, do you register your trade secrets? Like, I don't know, I need further clarification on trade secrets. Is there any like provision for registering your trade secrets? Is there anything like that?
Okay, thank you. For trade secret, the idea behind trade secret is that it has to be a secret. So you don't have to register a trade secret. But like I said, you have to put your works or your creative work in order for you to enforce it, you have to put it into documentation. How to basically protect your trade secret is to ensure like the utmost security for that quote and unquote trade secret. For example, let's say I'm Coca-Cola company, for example, and I want to maintain my recipe. I don't want to file a patent for the way I made the Coca-Cola drink. So the way I could do it, basically, I'll write the formula in whatever form, and then I would make sure that for employees that I actually bring under me, they have to sign something called a non-disclosure agreement. So what that basically helped me is that as long as you're working under me and you are with me, you are not to mention, or if you have access to that recipe, you will not be able to disclose it to a third party. And sometimes they have agreement that basically forecloses the employee from engaging in that similar industry after a certain year. So for example, I can restrict the person, it's called trade restriction. You can restrict the employee from going into any other company that manufacture drink for maybe 10 years, because by then it should probably just phase out from the person's memory. So another way is to make sure that you are actually protecting that trade secret, and you're actually making them sign something called a non-compete as well, so that even when they know about it, they won't be able to engage in the same business. Okay? Does that answer your question?
Yes, please.
Sorry?
Thank you. Yes, it does. Thank you.
Okay. Does any other person have like a question? Glory, you kind of unmuted at some point. Do you have something you want to ask? Hi, Glory, can you hear me? Okay, so I'm just going to continue. So IP in your business. I was asking if any person, Teresa, are you raising your hand, please? Because I can see a hand raised. Okay, so is anyone a business person here? I would like you to tell me about your business so I can define how IP actually affects your business. Or if you're a creative, if you have a work, basically. Now, I know nobody wants to talk, but basically, I need this to be kind of interactive so I know I'm making sense. So, if someone can please volunteer and tell me about his or her business, that would really be helpful. Okay, Grace, thank you.
Um, Good evening.
Good evening.
So I'm actually a lawyer, but I am also a legal advisor to uh, recent startup company, and the company is trying to get into the fintech space. So basically, the company has a website that allows students that are going abroad for their studies to pay their service fee online, service SEVIS.
Mm-hmm.
So something like that. And there's also their website like that, like Pay for Me. So the company is trying to do something similar like that. So that's one business that we're in. The company has been incorporated and it has a name already. So that's the reason why I actually came on this call, was to get more insight on how we can protect the intellectual property of the company. So that's an example.
Thank you so much, Grace. I appreciate the volunteering. Okay, so so please kindly unmute so I don't get feedback. Thank you. Okay, so for Grace's company, we can see that each of the intellectual property right actually applies. So let's start from copyright. So copyright will basically cover your emails, the emails from your company, basically communications, the articles you guys send out, the newsletters that you send out to your subscribers, those are protected under copyright. Your website, the way your website is presented or the way it's made, okay, the user interface basically is protected under copyright. And copyright is thankfully copyright is automatic, so you don't necessarily have to register for copyright protection. So as long as you create the work, like once you put it in a fixed form, like I explained, putting it in writing or documenting it, it is protected by copyright. But sometimes for most creative, what they do is to go a step further to do something called a notification scheme. A notification scheme basically means that you are taking the work to the commission for Nigeria. I know that's the Copyright Commission, and you are giving them notice that I have this work, right? So I need you to make sure that you know that we have this work in existence and we need it protected. So that's called a notification scheme, and it's more like a notice to the world that that work exists. So your emails, your communication, your website, your user interface are basically protected under copyright, and you don't necessarily have to register except you want to go like a step further to protect the work. Then basically you can do that. Then the next one is your trademark. Your trademark is basically covered by your business, your company's business name. So definitely you have to register for trademarks. Unlike copyright that applies automatically, for trademark, you must register actually. If not, there is no way you can protect it, because usually most countries operate on a first to file basis. So it's usually the first person to file or the first person to register that name is the owner of the trademark. So if your company has not registered its business name or its trademark, its logo, its slogan, please try to advise them to do that as well. And then another thing too is your domain name. It's not necessarily a copyright or an intellectual property protection, but most times we have some unscrupulous people going ahead because they know that a business is thriving. They go ahead to buy the domain name. So even if your company does not want a domain name, basically you can still try checking, because people that actually do that, they are called cyber squatters, and you can take actions against them to sue them that they are using your trademark in an unauthorized manner. Okay, so you can do that. Then patent basically will cover it depends on the country. Some country will protect software under patent. Sometimes it will fall under copyright. So depending on the country that your company is, you have to register your software design, because basically you have interface to pay the service fee, like you said. So you have to actually register the patent or the copyright. Basically, it's always advisable you register the copyright. Then a trade secret that will cover your company is basically your customers list. So that's what gives you a competitive advantage against every other person who does the same work as your company. So you can go a step further to make sure that people who have access to all these details that makes your company's work a bit more competitive than the others do not disclose it. So make sure that when your company is employing people or people who will have access to sensitive information, they are executing something called a non-disclosure agreement and also a non-compete agreement. I'm pressed for time, but we can always brush through this in the next series. Okay, so I'll just go briefly to the next one. Yeah, just to rush through IP for business. That's basically IP for business. And another thing I'm just going to say is that if you're an employer, you should make sure that, because ordinarily when an employee, that's a person who works for you, creates a work, it basically would be the intellectual property of the person. So in order for you to retain the intellectual property, you have to make sure that in the employment contract, you are passing the intellectual property to yourself. So you will make sure that whatever work your employee creates in the course of the employment will go to you. So if you're an employee, you will actually be on the disadvantaged side. So what you can always do is to make sure that you get compensation for your improvements in the company. Then for work, there's something called works for hire. So these are people that you contract. You can contract them to, for example, your photographer, if you're having a wedding and you contract a photographer, the intellectual property belongs to the photographer. So what you do in that instance, you have to make sure you enter a written contract to pass the intellectual property work to you. So that's I'm just going to run through it because we are kind of pressed for time, but you can always send me your questions and I will definitely answer you. Then I know a lot of us actually do, we actually try to get investors for our businesses and whatnot. So basically IP in your business pitch is just to make sure that somebody does not quote and unquote steal your idea. So in order for you to do that, you basically have to make sure that the person you are pitching to is signing the same thing, like I said, a non-disclosure agreement, and your lawyer will be able to help you with this. Sign a non-disclosure agreement. What that helps you do is basically to stop the person from using the same concept of the same idea. Okay. Now, most times we have investors that would not want to sign it. They just tell you that, my friend, see, if you're not ready to tell us this, just don't worry, just leave it. So what you can do in that is that you can always redact relevant and sensitive information. Don't go in depth, okay? Just try to give them like basic ideas, and they should understand because this is your intellectual property, and if you tell them more, they may take the concept, and I mean, you can really not do anything. Another thing is that when you send out slides or you send out communication, document it just in case they try to play a fast one on you. You can always sue them and get, compensation for them using your ideas. So when you are giving out confidential information or you are pitching ideas to people that do not want to execute a non-disclosure agreement, make sure you are redacting as much information as possible. So you just have to try and balance it, okay? Just so to keep yourself on the better side. Then I'm just going to talk through AI and tech. For AI work, basically, AI works are not protected under intellectual property because there is a requirement that intellectual property works need to be a man-made work, like it has to be a natural person. So AI has not been declared an artificial or a natural person, and that's why we are having a lot of legal discussions about how AI work can be protected. But currently, AI works are not protected. So when you generate a work, you tell ChatGPT, generate a picture for me, for example. Those kind of works are not protected under copyright law. So something you can do is basically to add something called human effort. So don't just leave it at generating the content or the work. Basically, don't just say, oh, ChatGPT, generate a work that has a boy and a girl. You just try and add some other thing like your own effort. Try to put in maybe colors. Just try to put in some effort from your own end, and it shouldn't just be AI generated. Okay, that will basically help you scale through it. So when they are asking you at the PTO, the copyright office, oh, how did you create this work? You can always tell them that yes, you use AI, but however, you're able to add A, B, C, D, and E, and that will probably give you some sort of leverage in registering the work. For technology, I'll just go briefly into Bitcoin, NFTs, and whatnot. You can always use copyright to protect your softwares, patent for the method that you used in making the algorithm. For your trademarks, definitely I know a lot of NFTs has like logos and names and whatnot, so you can always use trademark to protect it so that when someone else uses it, you can actually sue for infringement, get compensation, issue cease and desist letter and whatnot. Then, like I said, you can always use trade secret, okay? Always keep it. That's the idea. Keep it a secret. Don't let anybody know about it. Just put it on a need to know basis, okay? Don't tell people so much. And the moment it is exposed, you just know that you've lost that right totally. So that's why people don't risk it. They just go for patent instead, just so they are protected anyway. And then always ensure you use licensing agreement, okay? Usage rights, how people can sell and resell your Bitcoin, how people can display your Bitcoin and your NFTs, and then enter into smart contract. I'm so sorry I'm breezing through all of it. I'm actually kind of pressed for time. I will run through another webinar where we're talking in depth about each of these. But for now, let me just run through it just so we can get a general idea. Okay, for those of us who are content creators, like I said, copyright for your content, these are audiovisual work and they are protected by copyright. So I know a lot of you will like, I'm a content creator. I want my work to, it should be popular, but people should share. Yes, it can really help, especially when your name and your face is actually attributed to the work. But if it's something like a sound, for example, we know like the Nigerian artist, Sabinus, we know that, okay, he's used to saying investor move and something like that. So everybody uses that investors move, be investors move. I don't know if I'm saying it very incorrectly, Sha. So for example, now KPMG now just say, do an advert and they put investors move. Nobody will, apart from the fact that Sabinus is popular, let's imagine he's not popular. That trend will actually flow and nobody will know that it is from Sabinus. So that is really why you need to keep tabs with what or who is sharing your work so that the wrong people don't get credit or commercialization from your intellectual property that you're sharing. Then another thing you can do is to watermark your videos. Okay, there are different platforms, there are different tools you can use to watermark your product just to put your name so that even if somebody is sharing it in the future, your name will always still be there to show some sort of ownership and then the whole credit will come back to you. And then you can also use digital rights management tools. We have like Google with Vibe that Netflix use basically to stop people from screenshotting their screen and whatnot. So there are different tools you can actually use as a content creator to protect your work. Don't just say, I want my work to be popular, and then you just leave it like that and you may end up losing it if you're not lucky. So yeah. Okay, I am so sorry I had to breeze through because of time, but I'm open to questions briefly and I have left my email there. You can always reach out to me. I will be organizing another one. Basically we'll be talking about each of these one, IP in AI, IP in content creation. We'll be talking in-depthly about it. I just decided to give like a rundown of these things so that at least we can get a fair idea. So if you have any questions, please can you indicate? Okay, so I'm thinking that, okay, everybody understood, right? At least give me a thumbs up if you can hear me or like just raise your hand. Just give me a feedback so I know that I've not been talking to myself just to be sure. Okay, I'm just going through the chat. Okay, thank you so much then. So we don't have any questions, right? Okay, I'll be sending out another link soon just to run through this better. I'm so sorry I had to run through. Zoom was giving me like time limit. So thank you so much for joining. Please don't forget to follow me and share this when you can. Thank you guys.